Good afternoon, everyone, and welcome to the webinar, Ethical Considerations for Prosecutors in Sexual Violence Cases. My name is Charlie Whitman. I am an Associate Attorney Advisor at Equitas, the Prosecutor's Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will address the ethical considerations outlined in the description, as well as charging decisions, immunities, the investigative function of a prosecutor, and trial publicity. The presenters will use hypothetical case scenarios to challenge prosecutors to evaluate their decision-making in the context of ethical rules and principles. Before we begin the substantive portion of our program, I will provide a brief overview of our iLink webinar service. You can listen to this webinar either via computer or conference call. For the best use of iLink, I strongly recommend calling in from a landline to our conference line, which is 530-881-1212. Passcode 202-731-738. That number is also in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option and listen with an earpiece if necessary. If your call gets dropped, please call back into the conference line as soon as possible. All call-in participants have been automatically muted for the duration of the webinar. Also, today's webinar is being recorded for later viewing. To connect to Internet audio, please click the Connect button on your start screen. If you use the audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet audio. If you have technical issues during the webinar, you can use the iLink hand raise indicator, which is located on the toolbar in the top left-hand portion of your screen, above the presenter's photo and to the right of the conference call number. You can also contact iLink directly at 1-800-799-4510. Throughout the webinar, questions will be posed to all participants. You can respond to the questions by using the iLink feedback indicator located on the left-hand side of your screen. You can post comments or questions via private chat to me, Charlie Whitman, and I will share your questions anonymously with our presenters so that they can be addressed during the webinar. Today's webinar is hosted by Equitas, the Prosecutor's Resource on Violence Against Women, through funding from the U.S. Department of Justice, Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenters' biographies, will be emailed to you after the presentation. Equitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Equitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. Equitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, and provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenters are Christopher MALLIOS and John Wilkinson, attorney advisors at Equitas. Prior to joining Equitas, Mr. MALLIOS served as chief of the Philadelphia District Attorney's Office, Family Violence and Sexual Assault Unit. He also served as an advisor for the Philadelphia Police Department's Special Victims Unit and Internal Affairs Division, and co-chaired the Law Enforcement Subcommittee of the Philadelphia Domestic Violence Task Force. Mr. MALLIOS is currently an adjunct professor at the University of Pennsylvania School of Social Policy and Practice and an affiliate of the Ortner Center on Family Violence. Prior to joining Equitas, John was the program manager for Gun Violence Prosecution Program, the Homeland Security Program, and the Southwest Border Crime Program of the National District Attorneys Association. He also served as an assistant Commonwealth attorney in Fredericksburg, Virginia, where he was a member of the Fredericksburg Area Sexual Assault Response Team. John also served as an assistant public defender in Fredericksburg, Virginia. At the conclusion of this webinar, prosecutors will be better able to identify and respond to ethical issues in sexual violence prosecution. I'd now like to turn the floor over to Chris and John for the substantive portion of today's webinar.
Thank you for joining us, everyone. The goal of this webinar is really to help all the participants identify and respond to ethical issues in sexual violence prosecutions. These cases are unlike other cases because of some of the dynamics of sexual violence, some of the effects of sexual trauma on victims. You sometimes see issues that are unique to these cases. So we're going to work through this webinar with some real-life fact patterns drawn from real cases. And we're we're going to ask you for your participation throughout the webinar. We're going to start off talking about some quotes about the role of the prosecutor, and this comes from a Supreme Court case. We're going to give you the site in one of the later slides. But when you read the cases, the case law that deal with the role of the prosecutor, prosecutors are often described in very lofty terms as ministers of justice. And over again, what we see is the pleading that prosecutors should not just try to win cases and not just seek convictions, but the prosecutors should seek justice. And it's so important that in carrying out our roles as prosecutors, there's a twofold aim, which is that guilt not escape nor innocence suffer. So it's just as important to protect the innocent as it is to hold the guilty accountable. This slide has the site for the case we're talking about. It's a 1935 case from the U.S. Supreme Court. And this really encapsulates a lot of the ethical challenges. Prosecutors may prosecute with earnestness and vigor indeed. With vigor indeed, he should do so. I apologize for the fact that in 1935, when the Supreme Court was writing about prosecutors, they seemed to only use male pronouns. While the prosecutor may strike hard blows, he is not at liberty to strike foul ones, inasmuch as his duty to refrain from improper methods calculated to produce a wrongful conviction, as it is to use every legitimate means to bring about a just one. So again, we're talking about justice, seeking justice, doing justice, not just seeking convictions. And when we think about how sorry, John.
I was just going to say, when you look at those slides, what I always think about is how many times as prosecutors we've had to step out of our role as only the prosecutor and think about protecting either the record or protecting sometimes the rights of the defendant when perhaps defense counsel has not, or at least we think has not done everything they should be doing. And I'm sure people have had that experience. And I think that kind of characterizes exactly what those cases, or what that Berger case was talking about, is that we have to seek justice, and we have to make sure that the defendant gets a fair trial. We have to make sure the victim gets a fair trial in these cases. And sometimes that requires us to do certain things to make sure that discovery is not only delivered, but that the defense looks at it and acts appropriately in these cases. And I think that kind of characterizes it. I think where we get into trouble is sometimes when we get caught up in the competition of prosecution, as opposed to having that overview of justice, the big picture of justice, to make sure everything's conducted properly, that everybody has their day in court, essentially, a right to their say, and we make sure that the defendant gets a fair trial.
John, that's such a good point. You know, we practice in an adversarial criminal justice system, and sometimes when it comes to prosecutors actually needing to take steps to protect the rights of the accused, sometimes you're stepping out of the adversarial system to do what's most ethical thing, and it's not necessarily going to help you win the case, but it's the right thing to do. And so prosecutors really do serve not just your client, which is the state or the government, but the people and also the defendant, the accused. We also have a duty to the accused to make sure that the prosecution is ethical. So when you look at some of the typical ways that we think of achieving justice, we think of things like charging decisions made by prosecutors, participation in investigations, whether you're in an investigative unit of a district attorney's office or a prosecutor's office, or whether you're working with law enforcement officers, reviewing warrant affidavits, engaging in plea negotiations, trials, and all the decisions that prosecutors make when prosecuting a case, pre-trial, during trial, post-trial, up to sentencing, and even the monitoring of the offender, whether it's probation or parole. These are what we think of as the traditional roles of a prosecutor. But, you know, in 2013...
Just to go back real quick, and just as an example, I think about charging decisions. And when we get cases, do we charge every single charge that could possibly be charged? Very often we don't. We select an appropriate number of charges, and that's one of the ways we achieve justice. However, in other cases, such as child pornography cases, we'll typically charge every single image as an individual charge, and you end up with indictments that are hundreds of charges long. I think about the Castro case that just happened in Ohio and how many charges that guy had. So we do achieve justice those ways. We do make decisions about cases, and it's part of our role. And as Chris said, those are the traditional ones, just as an example in those cases.
And there's also a lot of strategy involved in some of those charging decisions. For example, the prosecutors in that Ohio case wanted to make sure that there would be enough charges for a sentence that was appropriate long. I think that offender ended up with a life sentence plus 1,000 years. And, you know, at some point it might seem like an academic exercise, but it was very important to those prosecutors that there'd be no chance that this offender ever be able to get out. And so, that, again, those decisions seeking justice, that was important in the decision that they made in that case.
That's a good point about strategy, too, where we'll often make strategic decisions even about what we charge. So we may charge a sexual assault case, but maybe we don't charge lesser included because we're afraid a jury may fall down and hang their hat on that. Sometimes we charge everything that can be charged, depending on what the facts of the case are. But strategy often plays a role in that as well.
Sexual assault cases are unique because there are multiple people. There are allied professionals who work with prosecutors, who work with law enforcement to help victims, to respond to victims, and to help victims obtain justice. Advocates, victim advocates are an important part of doing this type of work. Most communities are served by a rape crisis center or a domestic violence center, or in many jurisdictions there's a combined rape crisis center or domestic violence center. And those community-based advocates establish relationships with victims. They provide services to victims. The advocates are often very familiar with the criminal justice system, and working together with advocates can be a great tool to bring victims in, to keep them interested in the investigation and prosecution, and make sure that all of their needs are being met. There are a lot of services available to advocates. There may be opportunities to get financial compensation, such as crime victims compensation, access to civil justice. If you're working in a coordinated community response committee where the prosecutors, the law enforcement officers, the advocates are together, also bringing in people like mental health professionals, sexual assault nurse examiners, and the people who are running those programs, colleges and universities in the area, the faith-based community, even bringing in groups like the DNA or the criminalistics people who are working on testing the cases, the evidence that's collected at these cases. It's so important that all of these groups be working together, because when one player changes what they're doing or how they're doing it, that can have ramifications throughout the community and can really impact whether a victim feels like they're receiving a just result in the case. A lot of prosecutors are involved in training members of law enforcement, or going out into the community and training members of the community in schools, in community groups, in churches, mosques, synagogues. A lot of victims need help with civil issues. Sometimes they may be eligible for a protection from abuse order or a similar type proceeding, and just making it an appropriate referral to someone who can help them with those legal issues if the prosecutor is unable to do so, helping with economic issues related to loss of wages or out-of-pocket costs as a result of a traumatic sexual assault crime. These are all ways that a prosecutor can help move the ball forward and help the victim get access to the justice system. There are a lot of different ways, and even in the case that ends up not resulting in a conviction, if a victim feels like people were trying to help her or him, they were advocating for the victim, making appropriate referrals, treating them respectfully, all of these things go a long way to make a victim feel like they're coming into a coordinated system that really is committed to justice for victims and offender accountability.
Okay, so we're going to talk a little bit. So we're going to talk a little bit about a hypothetical to set up some of these issues. Just in the beginning, there has been an ongoing disagreement between the prosecutor's office and the local law enforcement agency regarding sexual violence investigation reports submitted to the prosecutor's office for filing review. The Special Victims Unit, so we'll imagine this is a jurisdiction where the prosecutors are the ones making the charging decisions, and they have a unit that reviews that. The Special Victims Unit, which handles felony-level sexual assault cases, prosecutors are complaining that the reports are bare bones and that officers quit investigating the cases once they have probable cause to arrest a suspect. The law enforcement agency complains that the prosecutors want more information than is necessary. They also point out that the prosecutor's office has investigators assigned to the SVU and that those investigators can do follow-up investigation if the prosecutor feels it is necessary. So before we get, in an attempt to alleviate the tension, your elected DA has instituted office hours from 3 p.m. to 5 p.m. every Thursday. During this time, law enforcement officers can bring cases to discuss with the SVU prosecutors. You work in the SVU unit. So before we get into the meat of the hypothetical, Chris, do you want to talk about some of the sources of authority that we're going to rely on throughout this presentation?
Yeah, we're trying to give you a realistic background case to deal with. And we know that there's sometimes ongoing tension between prosecutors and local law enforcement agencies about how much investigation law enforcement needs to do on the front end. Is it just their job to give you enough to make a probable cause determination, or do you really need them to investigate the case much further to give you enough evidence to really tie the whole case up in a bow for the judge or jury? And there are ethical issues that really do arise in making this determination. And we want to just mention what the sources of authority are, because this is really important. What we're talking about here is an attorney's license to practice law. If you violate these ethical rules, potentially you could do something that violates that could jeopardize your license to practice. It could also get you in trouble with your office, and it could get your office in trouble. So the first thing to look at are the rules of professional conduct. These are promulgated either by legislatures or by Supreme Courts or by committees, and these are the rules that govern the practice of law for prosecutors and for all attorneys. There's also case law. There could be case law interpreting the rules of professional conduct based on disciplinary cases that have gone up on appeal. There also may be case law based on allegations of prosecutorial misconduct that have gone up through the appellate courts of your jurisdiction. So you want to know what's out there. By the way, in terms of the rules of professional conduct, because the participants in this webinar are from a lot of different jurisdictions, we will be referring to the model rules of professional conduct promulgated by the ABA. Most state rules of professional conduct are based on these rules. Some of them are verbatim, but we encourage you to take a look at the rules in your own jurisdiction and be familiar with them. In addition to case law, there are advisory opinions that are available. Some disciplinary boards in the states and some Supreme Courts in the states issue advisory opinions upon request when a lawyer has an ethical dilemma, an ethical question. Many jurisdictions permit lawyers to write in or call in to the disciplinary board to get an advisory opinion, and those advisory opinions are usually published and available because many of these issues do come up again and again. The American Bar Association also promulgates standards for the criminal justice function and for the prosecution function. These standards tend to be a little more detailed, and they can also provide some guidance because they deal with more specific issues. And of course, you always want to know what your office policy is on an issue. You certainly don't want to get in trouble with your elected or appointed district attorney or with your supervisors, so you want to know what your office policy is. But you should never follow a policy that violates the rules of professional conduct, and it's so important to stress that. Again, you don't want to do anything that's going to raise questions about your ethics or jeopardize your ability to practice law in your jurisdiction.
Yeah, that's a good point, Chris, and I just wanted to point out that every state bar has an ethics either hotline or number that you can call and give them the hypothetical situation that you're in, and they'll give you the rules that apply, and perhaps they'll even give you more than that, some additional guidance. You can always talk to other folks in your office about it, but just remember, your license is your license, and you can't be directed by an office superior or an office policy to do something that violates those rules. Just get information. Don't make these decisions cold. Don't make a blind decision. If you're feeling uncomfortable about something, that's when you really should seek out advice and information from other sources, like particularly a state bar hotline that can be extremely helpful in those cases.
John, that's such good advice. In my personal experience, I can remember talking to some very, very senior attorneys in my office about some ethical issues pertaining to discovery. And they took a very, very restrictive approach to what needed to be turned over that actually, in my opinion, was even before Brady, because that's when they started prosecuting. So you can't assume just because someone is a senior in your office and has a lot of years of prosecuting cases, that doesn't necessarily mean that they're doing things the right way. So yeah, get your advice from the right places. I mentioned the model rules of professional conduct, and also that we're going to talk about the ABA standards. So the model rules, the ABA's model rules, which we're going to refer to in this webinar, were promulgated by the ABA Center for Professional Responsibility, and they were really intended to provide guidance to policymakers. This was back in the 1970s when a lot of states did not have strict rules governing the professional conduct of attorneys. As a result of this, the ABA promulgated these rules with general standards of behavior for lawyers, and they were extremely influential in states' decisions to enact these rules. 40 states have adopted their own version of the rules based on the ABA's model rules. And as I said before, many states just adopted the ABA's model rules verbatim. And when the ABA amends the model rules, a lot of states also enact the amendments. Some states started with the model rules and then based on the unique situations that arose in those states and based on state law have amended them. So as I said, we're going to be referring to those model rules, but you want to know what the rules are in your jurisdiction. The ABA also has standards for criminal justice for the prosecution and defense functions. These are also promulgated by the ABA, but a different section of the ABA, and they are much more specialized. They're much more specialized than the model rules are. They're also intended to guide policymakers, but they're also there for you, the practitioners. They're much more specific, and they sometimes have the weight of law because they're cited by appellate courts, including the U.S. Supreme Court, when they have cases that address issues of prosecutor ethics. So it's always a good idea to take a look at those when you have an issue. They are available online, and when they are adopted by an appellate court, you can consider them binding, and you can consider them as though they are almost like an amendment or an addendum to the model rules, to the rules of professional conduct in your jurisdiction.
Okay, so back to the hypothetical. So we have this policy where you can meet with the prosecutor during those office hours, so an officer brings in a case to discuss with you, the prosecutor. You're the prosecutor in this case. A 22-year-old female victim was at a local bar frequented by college students. She was dressed provocatively and consumed several beers. She accepted a ride home from the bar with the suspect. 2 days later, the victim reported to police that when they arrived at her apartment, the suspect entered her apartment behind her and raped her. 2 of the victim's friends saw her leave the bar with the suspect. The victim reported the rape to the police after she disclosed what happened to one of her friends and was encouraged to report it by her friend. The officer asks you, is there anything else you want me to do in this case? How do you respond to that officer? Or are there any issues you're thinking about while you're trying to respond to that officer, or how you're going to respond to that officer? Anything that you think of? And we're going to let you make a private chat to Charlie, our moderator, about any responses that you might have to this question. He's telling you, is there anything else you want me to do, and what issues are you thinking about in responding to him?
So let's just go back to the previous slide and just give them a sense. Let's let the participants reread these slides while they're coming up with their questions or their answers. Apparently that's the officer's language, that he thought the victim was dressed provocatively in this case.
And again, these are sort of classic items that you find in reports when you have a delay, an allegation that somebody dressed provocatively, they do not initially report to police, talk to a friend first. Those are all classic dynamics and classic fact patterns in sexual assault cases.
And we know from our own experience and from doing training all over the country that different offices take different approaches to this issue. The question of how much leadership should prosecutors be giving to law enforcement officers in these cases? Should prosecutors be directing the investigation? Should prosecutors be hands-off in this and just let the officer do their job and then let the prosecutor make a decision about charging or about prosecution? We know that there's a great deal of variability, and there are legal ramifications for how involved a prosecutor gets in this type of decision when working with the law enforcement officer.
So let's talk about that, Chris, in terms of immunity.
And this is not purely an ethical issue, although it does certainly have implications in the ethical realm. Prosecutors have immunity that's similar to the immunity that judges have, which is absolute immunity. Prosecutors have absolute immunity for functions that are intimately associated with the judicial phase of the criminal process. And there's a 1976 case from the U.S. Supreme Court, Imler versus Patchman, that really talks about that and sets forth what that means. When we're looking at functions that are intimately associated with the judicial phase, we're talking about initiating the prosecution. In other words, the charging decision, the filing of charging documents, presenting the case in court, calling witnesses, making arguments, filing motions, arguing motions, drafting legal documents, making a determination about whether there's probable cause to proceed. I know that in some jurisdictions, prosecutors make charging decisions. There are other jurisdictions where law enforcement makes the initial charging decision, and then prosecutors pick up the case after that. So whether it's the decision to file charges or the decision for the charges to go forward, all of these things, presenting information and motions to court, all of these things are considered intimately associated with the judicial phase, and they entitle prosecutors to absolute immunity. Absolute immunity is important, because when a prosecutor has absolute immunity for something that they do, if the prosecutor is sued, an attorney representing the prosecutor can have that suit dismissed, even without discovery. If it falls within some of these functions, you don't have to be deposed, you don't have to respond to interrogatories. Absolute immunity just terminates the lawsuit without discovery. Absolute immunity does not include acting as your own investigator. So maybe prosecutors, for many good reasons, want to go visit the crime scene or go out and talk to witnesses. There are lots of reasons why you want to do that. That is not considered something that's intimately associated with the prosecution function that would give you absolute immunity. Giving legal advice to the police during the investigation does not qualify for absolute immunity. If you yourself are the affiant on a search warrant or arrest warrant, and you're attesting to the truth of facts in support of a warrant, or if you sign the affidavit, you are not qualified to absolute immunity. So back to our hypothetical, the officer asked, is there anything else you want me to do in this case? You have to make a decision about what you want to do, but you need to know that giving legal advice to the police about how to handle the investigation could amount to a waiver of your absolute immunity. Now, you still have a form of immunity for that, but it's qualified immunity. And the big difference between absolute and qualified immunity is that if absolute immunity applies, the case can be dismissed. If qualified immunity applies, then the case will go forward, but there's a high burden for the plaintiff to obtain a judgment against you. So if you're offering legal advice to the police about an unarrested suspect, if you're doing police investigative work or becoming involved in that, the administrative activities of a prosecutor, when the functions of prosecutors and detectives are the same, the immunity that protects them is also the same. And that's a direct quote from the Buckley versus Fitzsimmons case. The standard for holding a prosecutor liable under qualified immunity is that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So we're not talking about a mere negligence standard. The conduct has to violate clearly established statutory or constitutional rights of which a reasonable person would have known. So it's harder to sue a prosecutor and hold a prosecutor liable than it is to hold other people liable. But still, once the prosecutor becomes involved in that investigation and starts to direct the investigation, they're no longer entitled to absolute immunity. They're entitled to qualified immunity. It's a higher standard, but it would be a lawsuit that needed to be defended.
And Chris, I just wanted to note that, so there's nothing unethical at all about directing those investigations. It's not an ethical implication, but it's just being aware of the implications of making that decision to give advice to police and police during investigations. I was in a very small rural office in Fredericksburg, Virginia. We had 4 prosecutors, including our elected, and we worked closely with the police. And so we definitely were involved in those investigations and definitely made that decision to really sacrifice that absolute immunity, but still be covered by qualified immunity, which still gives you some protection. And Chris, I know you were in a big city office in Philadelphia.
Yes, we were also very involved in investigations, especially in our homicide unit and in our family violence and sexual assault unit, which I was in charge of. I would get calls in the evening. I would get calls after hours, and we were very involved in that process. And we made a decision as an office that we wanted to be that involved. We wanted to make sure the investigations were the best possible investigations. And we made a decision that we would rather have good investigations and make our charging decisions and prosecution decisions based on all the evidence, all the facts and evidence that we needed. And we were willing to waive that absolute immunity. In an office with 300 prosecutors, we had a civil litigation unit of 3 prosecutors and also a support staff in that unit. And that unit defended us from any allegations of error, of malfeasance. And these cases came up once in a while, and sometimes the cases went forward. We never had one where a prosecutor was actually held liable while I was working there, but it's something to think about. We're going to talk a little more about some of the ethical issues associated with the prosecutor's desire for a full investigation, but that's a really good point. There's nothing unethical about getting involved in that investigation and directing the investigation. It's just that you should do that knowing that there are civil law ramifications for that.
Okay. So back to our hypothetical. Can you charge the suspect based on the information provided by the officer? So remember that the officer knows that this is a report from the victim, that she went to the bar, went home with the offender. 2 days later, she makes the report, but when he went in behind her into the house, she tells the officer that he raped her. Can you charge the suspect based on the information provided to you by the officer? Please indicate yes or no using the feedback option on your left. Okay, and I'm seeing some responses we have, and it's changing as we go. About 60% are no, and about 40-some%. Now it's 50-50, yes and no. And so there's a bit of a split in the answer here. And so what I want to go to is the charging decision. This is Model Rule 3.8. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So when we think back about what are the facts that we have so far, and I understand that people are probably responding no because they definitely want more investigation at this point. They want to know more about the case. But ethically, when probable cause is the standard, that is the standard per the model rules, there is enough to go forward in this case. There is enough to charge. Now, practically, you may not be comfortable doing that until you get a thorough investigation. And, of course, we want thorough investigations in all our cases. That's the key to these sexual assault cases. They're extremely difficult cases to try. We need to do thorough investigations, believe our victims until the investigation reveals a reason not to believe our victim, and for no other reason. And we want to go forward, and we want to pursue these cases aggressively. But the standard is probable cause, and so we want to remember that. And based on the information that the victim has provided, there is probable cause to go forward. And also remember that the victim's testimony alone is sufficient for a conviction in these cases. Almost every jurisdiction should have either a jury instruction to that effect, or that should be the law in their jurisdiction. And that's true not just in sexual assault cases, but in every case. If the victim is believed by the jury, and the victim's testimony alone is enough to convict. So we want to remember that when we're talking about these cases. And now this is
that's a great point, John. There was a time in the jurisprudence of this country when the uncorroborated testimony of victim was deemed legally insufficient to charge or obtain a conviction. And that rule, that corroboration requirement, did not exist in any other area of criminal prosecution except for sexual assault cases. And there are still vestiges of that law. Some people think that, especially older people that may find their way onto the jury, sometimes may find their way onto the bench, may have in their mind what the law used to be, and that there is still a corroboration requirement. But the ethical rules say that you need proof beyond a reasonable doubt to file a charge. You need probable cause to file a charge. You need probable cause to file a charge, not proof beyond a reasonable doubt. And sometimes it's described as the difference between whether you can file charges or should file charges. And sometimes when people do not file charges in sexual assault cases based on the victim's uncorroborated testimony, sometimes they say, well, it wouldn't be ethical to do that. We need more proof because it wouldn't be ethical to file charges based on probable cause standards. But the rules that govern what lawyers do really do speak to probable cause, and that's where, again, we're using the model rule 3.8, but that rule is the same in every state, and the federal rules as well.
That's a great point, Chris. And the ABA standards for prosecution and defense functions talk about this directly. It talks about how we exercise our judgment and the power that we have as prosecutors. Prosecutors are not obliged to present all charges which the evidence might support. Prosecutor may, in some circumstances, and for good cause consistent with the public interest, decline to prosecute, notwithstanding that sufficient evidence may exist which would support a conviction. And we do this all the time. We have a lot of latitude. We have a lot of discretion in all of our cases to go forward. But it's important to remember that the ethical threshold is probable cause. Even if you look down the road and think about and talk about being able to prove a case beyond a reasonable doubt, it's important to know that probable cause is the ethical standard, and we cannot go forward in cases where we don't think there's probable cause. But there's lots of reasons and lots of justifications behind what that discretion and some of the factors that we typically consider when we're exercising our discretion is the prosecutor's reasonable doubt that the accused is in fact guilty. If you have doubt, then that may not be a case you're going to go forward in. You want to factor that in. The extent of the harm caused by the offense. This is classic in our exercising our duties. We always think about these things when we're trying to achieve justice in a case, deciding whether to charge, whether to go forward in that case or not. The disproportion of the authorized punishment in relation to the particular offense or the offender. And some of these things may not be powerful considerations in a sexual assault case, but these cover all the kinds of cases that we approach. And so sometimes we'll get a case where the punishment that somebody's going to undergo for some minor offense is something that would make us not want to go forward at all. I just sort of remember in my own jurisdiction that we would have cases where people would call in complaining. We had a gas station calling and complaining that another gas station was giving away free gas in violation of a rule that the way they were doing it amounted to gambling or something. But it was just a case that we didn't want to go forward with. And there are all sorts of cases that people sometimes don't want to go forward in. Possible improper motives of a complainant are things that we take into consideration. Reluctance of a victim to testify. You know, when we're doing sexual assault cases, we always want to be very victim-centered. Think about the victim's wishes, involve the victim in the decision-making process of the case, and make sure that the victim is up to going forward. And we want them to be thoroughly informed at every stage of the case, but we want to involve them to the degree that we can into the decision-making. And that may be something that is a decision that you make that they really don't want to go forward for some reason. Cooperation of the accused. Again, probably not in a sexual assault case. If they cooperate in another case, are we going to take that into consideration? But obviously, when in all sorts of cases, when defendants roll over on co-defendants or cooperate, in another investigation or help out in an investigation, we take that into consideration. Availability and likelihood of prosecution in another jurisdiction. If we feel like justice will be achieved in another jurisdiction, that may be the factor that has us go forward in that case.
All these factors really point out the fact that prosecutors do have a great deal of discretion in deciding what cases go forward. And for a very long time, that discretion was used to keep sexual assault cases out of the criminal justice system, and also to keep domestic violence cases out of the criminal justice system. Even child sexual abuse and physical abuse cases were sometimes kept out of the criminal justice system. These are sometimes uncomfortable subjects. Some of these cases, many people thought were personal, private matters that did not belong in the criminal justice system, especially in the case of non-stranger cases or spousal or domestic violence, sexual assault, and partner sexual assault. But the truth is that these cases are profoundly impactful for victims. And when victims are reaching out to the criminal justice system for safety, for justice, for offender accountability, if there is somehow a higher charging standard applied to these types of cases that are applied to other cases, then victims of sexual violence are really being denied access to justice in the criminal justice system. So we really need to think about how we can apply an even-handed standard, apply the same standard in drug cases, robbery cases, DUI cases, and apply that probable cause standard in sexual assault cases. So going back to our hypothetical, we got sort of a bare-bones police report from the investigator. So the question we want to ask now is, what additional information do you want? And how do you go about getting that investigation, especially if you don't want to participate in the investigation of the case and waive your immunity, your absolute immunity? There are a lot of things in this case that you might want to look for. There may be additional things that you want to know before you make a charging decision. Are there witnesses? Maybe the sexual assault happened in private, but did anyone see the victim immediately before or immediately after the prosecutor? Was the victim treated? Was there a sexual assault forensic examination? What do those medical records say? Was there forensic evidence collected? Was it submitted for testing? What do those test results say? Was there enough to get a DNA sample? What do you know about the offender's background? Is there a prior arrest record? Are there prior convictions? Is there a record in other jurisdictions? Were there prior protection from abuse orders against the offender? Does the victim have a record? You might want to know that too. Maybe the crime scene. Has the crime scene been processed? Was there a crime scene, or was there some physical evidence that perhaps could have been recovered or could still be recovered? Sometimes you're going to have cases involving where you may have access to video evidence. For security reasons, a lot of bars and restaurants have video surveillance equipment. Sometimes public areas like colleges and universities, apartment buildings may have them. So there are just a lot of things you may want to look for. Was there a 911 call? And what was said on that 911 call? Is that something you might want to take a look at? Who's the first person that the victim told about this incident? So many victims, most victims of sexual violence never report to law enforcement. The reporting rates are running around, based on the most recent studies, around 20 to 25%. And that number is going up from the studies that were started back in the 1970s. But so we know reporting rates for sexual violence are low, but many victims tell someone other than law enforcement before they come forward. And you might want to know, who is that first person that the victim told? Did the victim tell someone that night or the next day? That person needs to be interviewed. Their statement may be admissible as an excited utterance or a prompt complaint or some exception, a statement of present sense impression. Some exceptions to the hearsay rule may apply, and that could be very powerful evidence, especially in the case when someone does not call the police right away, but they did tell someone else right after it happened. In terms of how to get information with investigating without personally taking over the investigation, sometimes just asking a police officer, a law enforcement officer questions. is there criminalistic evidence? Was there a medical examination? Are there witnesses? Did you find out who else the victim talked to? Did you get the 911 tape? Sometimes just asking questions could be seen as a way to tell the officer that you have outstanding questions, yet not be in a position where you're actually directing the investigation. The rules, the ABA standards look at the investigative prosecution function of a prosecutor, and they talk about that. And the ABA standards really do recognize that prosecutors do rely on police and other investigative agencies for the investigation of crimes, but the prosecutors also have an affirmative responsibility to investigate suspected activity when it's not adequately dealt with by other agencies. So, if you have a case and it's not being thoroughly investigated and you're not comfortable going forward, you want to make sure that everything that can be done is done. The ABA standards recognize that and recognize that sometimes prosecutors need to direct an investigation a little more. You may need to have your district attorney detectives, county detectives, they have different names at different offices, but maybe the investigators who are working in your office may need to take the next step because you want to make sure that you're doing the right thing. That decision to file criminal charges against someone is a profound decision. In many ways, that decision can be even more life-altering than the decisions that the judge makes in a case. And the ABA standards really recognize that if you're getting bare-bones investigations and you can't get more from the local law enforcement agency that you're working with, that you may need to step in and do a little bit more to make sure that you have more than a bare-bones investigation. John, you want to talk about Crawford?
Yeah. So, we do these thorough investigations, or we want to do thorough investigations in these cases, and we gather all sorts of information, but we have to remember the admissibility of that evidence. We have to remember, even if we gather all this information, what can we get into evidence and what can't we? Because that's going to affect how we decide whether we're going to charge and go forward or not. I'm sure everybody's had cases where they knew the defendant had done something, was guilty, but they just couldn't quite prove it. So we have to consider Crawford v. Washington, the 2004 case that affected really how we do a lot of our violence against women cases. And just a quick refresher on Crawford, the Crawford case divided out-of-court statements into two categories, testimonial and non-testimonial. And there are different rules for how we get that evidence in. A statement is testimonial. It's sometimes characterized by being a little more formal. It may be made to a government agent, and there's statements made where the declarant would anticipate that these statements are going to be used to charge and prosecute somebody. And so those are testimonial statements. And the only way to get testimonial statements into evidence is to have the declarant present and have them subject to confrontation and cross-examination per every defendant's Sixth Amendment right. So that's how we get those in. Unless there was a prior opportunity to confront and cross-examine that witness, that's another way to get a testimonial statement in. And then the third way to get a testimonial statement in is if the defendant has engaged in some wrongdoing whereby he forfeits his Sixth Amendment right to confront and cross-examine the witness against him. So think about that whenever you have a case, that forfeiture by wrongdoing is another way that we should always be examining to figure out if we can get statements in that might not otherwise come in because we don't have our victim present to testify. Non-testimonial statements are not subject to confrontation. So think about the situation that Chris was talking about a minute ago in sexual assault cases. They're generally not reported to police in the vast majority of cases. And even those cases that do end up being reported to police, typically an individual, a victim, will report or tell a friend or family member, a close acquaintance, a close person to them about what happened before they call the police, and often they're encouraged by that person to call the police. So think about those as non-testimonial and those sources of evidence that we can get in because we don't have the Sixth Amendment confrontation claim. But you do still have to have a hearsay basis to get non-testimonial statements in. So even if you can develop non-testimonial evidence, non-testimonial statements that can come in to evidence in your case, you still have to have a hearsay exception to get those in. And we have resources online that you can check out that cover Crawford, that cover forfeiture by wrongdoing. It's very easy to access and go over those. But you got to think about Crawford when you're assessing your case. It's not just gathering all that evidence. That's great. That's the first step. Step two is analyzing the evidence. Is it admissible? Can I get these statements in? Can I get this piece of evidence in based on the rules of evidence and based on the case law?
So let's go back to our hypothetical case. The detective interviews the victim in the case and calls you to tell you that he isn't sure he believes her and he wants to administer a polygraph examination to her. Can the officer do this? Please use the yes or no function on your feedback. Let us know what you think about this. He's asking you for legal advice here.
So we're getting some responses, and it's about 90% no and 20. Oh, now it's 80% no and 20% yes. Let's just go with that. People are still chiming in, but you got about 80% no and 20% yes.
I know we're asking a lot of you on a Friday afternoon, but we really want you to be engaged. Yeah, this is a really bad idea. The Violence Against Women Act was amended in 2005, and it states now that jurisdictions are not eligible for stop funding if their policy or practice is to ask victims of sexual assault to submit to a polygraph examination as a condition for proceeding with the investigation of a crime. Every state is receiving stop money, and the stop money pays for prosecutors in some jurisdictions. It pays for police and district attorney investigators in some jurisdictions. It pays for victim advocates and also victim witness coordinators in prosecutors' offices. So it's really important that this money be coming in, and if states or jurisdictions have practices of administering polygraph examinations as a condition to decide whether a case should go forward, that's really problematic, and it could potentially jeopardize VAWA stop funding. There are some other problems with this, and the big problem is that polygraph examinations, and it really underlies the reason that these examinations are inadmissible in court and why VAWA says not to use them. What they measure is stress. And in the case of a polygraph exam, they're trying to measure stress associated with anxiety related to deception. In other words, if someone is telling a lie and they have anxiety about that, then there are going to be some physiological stress reactions, a change in their heart rate, a change in their blood pressure, a change in their respiration rate, and also a change in the amount of sweat in the skin. And the test is called skin conductivity. And they use electrodes on the skin to measure how moist or how dry the skin is. The problem with asking a sexual assault victim or a victim of sexual trauma about what happened to them and measuring these stress reactions are that when you ask someone to think about and talk about and relive a sexually traumatic event, you're going to have some of the same physiological reactions to stress that someone might have if they had anxiety associated with lying. So their inherently reliability when used on sexual assault victims, it's hard to get a baseline, and it's hard to really understand these results just because of the nature of sexual trauma. Even though a victim may act perfectly calm and may discuss an incident of sexual violence in an apparently calm way, there could still be extreme physiological stress reactions that would be picked up on a polygraph examination. So polygraphs sometimes do have a role in an investigation. In my jurisdiction in Philadelphia, they were sometimes used to get offenders talking, and they were used as a tool to get offenders who were otherwise unwilling to talk about their involvement in crimes, get them talking, but they really are inherently unreliable when it comes to administering them to victims, and it's also just a violation of the Violence Against Women Act. Another thing that you should look out for is when a defense attorney comes to you and says, my client is innocent, he passed a polygraph examination, here are the results of this. A lot of times you know very little about the circumstances under which that polygraph was administered. Again, this is a test that measures anxiety and stress associated with deception. One of the tools for beating a polygraph is to take an anti-anxiety medication, like a tranquilizer or a Xanax or even alcohol. And there are things that you can do chemically. There are even websites dedicated to how to beat a lie detector. And when a defense attorney comes and says, "Here, my guy passed, drop the charges," or don't charge them, that's telling you next to nothing. There's a really good reason that these tests are not admissible in court, and so they really should not play that much of a role in charging decisions. Again, to get someone talking may be helpful, but not to make ultimate charging decisions about these cases.
You know, and Chris, just another thing, if this is happening in your police department, the message that sends to victims is horrible. We don't do that in any other crime, and it's sort of based on this false impression that victims of sexual assault will often make these charges up. And the good research actually shows that it's the incidence of false complaint in sexual assault is about the same as false complaint in every other charge, every other type of crime. And so we don't require people who complain that their car was stolen or their house was broken into to take a polygraph test. But for some reason this happens in sexual assault cases, and you have officers that just inherently are disbelieving of victims, often because they don't understand the dynamics of sexual violence and that victims behave in a certain way as a result of the trauma of sexual assault that they don't understand, and they make inaccurate credibility assessments of victims because of that. So it's not enough just to tell, if you have a department that's doing this as a policy, it's not enough just to tell them to quit it. That's a red flag, and you should look into what's going on with that investigation unit or that investigator, that they want to do this all the time, and make sure that they understand the dynamics of sexual violence and that they're educated on it, because that's the only way you're going to be effective in these cases. And you don't want to put victims through this and make the victim feel like they shouldn't have reported, because now they're not the victim, they're the suspect in the case. It happens all over the place, and we got to keep an eye out for that.
And if anyone's having trouble with some of the law enforcement agencies in your jurisdiction, they want to do this, we have some resources through the National Sexual Violence Resource Center about how these types of policies really do re-victimize sexual assault victims. And if after this webinar is over, if you just shoot us an email, we can get it. We can send it out to you by email.
Okay. So back to the case. Further investigation reveals the suspect's DNA is present on the victim's bedsheet. The victim has dropped out of college. Sexual assault charges have been filed against the suspect. During your interviews with the victim, she lies about minor facts, but not the rape itself. Based on your review of the case, you believe that the rape was perpetrated. Can you still go forward with the case in this situation? So you believe that the rape happened, but the victim has lied about certain things. And this happens in these cases for lots of reasons. The victim embarrassed about something that happened and doesn't want to reveal that. The victim, maybe it's a campus case and there's a zero tolerance policy for drug use, or there's some policy about underage drinking and there may have been drinking or drugs involved, and victims sometimes are reluctant to be straightforward about that. But the rule is candor towards the tribunal. And the rule tells us that, yeah, we can still go forward in that case. A lawyer shall not knowingly offer evidence that the lawyer knows to be false. If a lawyer has offered material evidence and comes to know of its falsity, the lawyer shall take reasonable remedial measures. So the key there is that material evidence part. If a victim lies about some immaterial side issue that is not important to the case, we can still go forward in that case. If there is some lie or something that they've not been straightforward on, we would always want to alert the defense about that and make sure that they're aware of that and exercise that due diligence, that requirement that we turn over any kind of mitigating evidence. But it doesn't prevent us from going forward because they said, no, I wasn't drinking that night, and it turns out there was, or that you have a BAC, or they weren't smoking marijuana or something like that, and it turns out that you have evidence that shows that they do. We want to be completely open about those things, but it does not prevent us from going forward in our cases. So we just need to remember that.
And I think it's worth mentioning here that really the best practice is to get the victim to tell the truth about everything. Sometimes when victims engage in petty crimes, as John was saying, they may be afraid of getting in trouble for something like underage drinking or smoking pot. And if there's not a prosecutable case there, if they're not going to get in trouble for that, they need to know that, and they need to come clean. If someone's going to be convicted of a serious crime like sexual assault, they should be convicted based on truthful testimony. As John said, sometimes colleges have very strict policies about drugs or alcohol. Some colleges have very strict policies about extramarital sex. And someone may be afraid to admit that they engaged in some measure of consensual sexual activity before the sexual assault occurred. Again, freeing them up, sometimes even working with the campus to make sure that victims are not penalized for coming forward and taking that brave step of reporting sexual violence, bringing the campuses into your coordinated community response team and talking about things like amnesty from campus judicial proceedings could be really important and a very, very valuable way to let them know that it's a way to reduce sexual violence on their campus by encouraging victims to come forward and creating an atmosphere where they can make a truthful disclosure. In some cases, we know that sometimes sexually exploited women, women who are working in prostitution, are victims of sexual violence at tremendously high rates. The research shows that so many of these sex workers are victimized and are raped, and also creating an atmosphere where someone in that situation can walk into a police station and say, I was working, I was doing sex work, but someone that I got into a car with then raped me. These cases can be tried and they can be successfully prosecuted, but it's so important that the truth be the basis of the victim statement and that the victim not go into a police station starting out with a lie. That can make it very difficult to win a case when the victim's credibility is so central to proving the allegations. So we'll go back to our hypothetical case now. You're preparing for trial, and you discover that the victim was previously charged with public indecency and misdemeanor for exposing her breasts outside a local bar. All charges against her were dismissed. Is the prosecutor obligated to disclose the prior charge to the defense? We'd like your feedback on this. Could you just say yes or no, whether you think that there's a rule, an ethical rule, or a case that requires you to hand this over to the defense?
And it looks like as the answers come in that we're, 82% saying no with 18% saying yes and fluctuating a little bit up and down.
Okay. Thanks, Charlie. Well, let's look at the discovery rule. A prosecutor should not intentionally fail to make timely disclosure to the defense at the earliest feasible opportunity of the existence of all evidence or information which tends to negate the guilt of the accused or mitigate the offense charge, or which would tend to reduce the punishment of the accused. So these facts, just to go back to our slide, does that negate the guilt of the accused? Probably not. It's an arrest. It was an accusation. It did not lead to a conviction. It's certainly not crim and falsi.
Chris, you got to explain what crim and falsi is, because not everybody's a Philadelphia.
Crim and falsi is a crime involving dishonesty. In most jurisdictions, not just Philadelphia, you can impeach a witness for a crime involving a conviction for a crime involving dishonesty. Someone who has been convicted of theft or perjury or some other crime of dishonesty where dishonesty is an element of the crime, usually a witness who has a conviction within a certain period of time of one of those crimes would be they could be cross-examined about that. Now, even if a prosecutor does choose to make a disclosure, I know in some jurisdictions they just give over the arrest records of all of the witnesses whatever's in them. This is something that would probably not be admissible in trial. It's unlikely that there's a theory that the defense could argue that would be legally relevant. They may try and admit something like this to try and attack a victim's character, perhaps attack the victim's likability under the theory that if the jury doesn't like the victim, they may not believe the victim and they may not want to convict the offender based on this. But even if it is handed over, a motion to exclude this evidence, to preclude the defense from cross-examining the victim about it, from introducing any extrinsic evidence of it, and from making any comment about it, would probably be the best strategy in a case like this.
Yeah, and another thing to remember about this, because I kind of agree, you probably are not ethically required to turn that over, but as a best practice, it is probably smart to turn it over and then move to keep it out. You don't always know what the defense theory is going to be. And so I've had cases where things have popped up where it's just like, well, geez, I never anticipated that's what they were going to make a defense on. Because you don't always know what's going to play into that. And so just as a best practice, I think you probably, this is something you want to turn over, have full disclosure in these cases. Not that you have to have a rule about automatically turning over a victim's prior record, et cetera, but just turn some of these things over and then immediately move by motion in limine to keep it out.
And in a lot of jurisdictions, the defense has the same access to criminal records that prosecutors do. But John makes a good point. Sometimes a piece of evidence, when it has not been disclosed and the defense finds out about it later, sometimes it takes on much more significance than it would have had it been disclosed pre-trial. So sometimes just to remove future appellate issues, prosecutors elect to do these types of things and almost over-disclose and overshare. I'm going to show you the rest of the model rule here. But if you do turn it over, think about the victim and the victim's privacy and what you need to do to protect the victim and the victim's reputation in court. Maybe the defense would somehow try and argue that this steers his rape shield. It probably doesn't. I can't think of a theory where it would. But again, you don't want to be in a position where the defense could argue, I would have filed a rape shield motion if I had known about this. John, you want to take this?
Yeah. So the victim calls you to tell you that she just read an article about the case in which the defendant's attorney told the reporter that everyone will know his client is innocent when they hear about the other man's DNA discovered on the victim's panties. Was the defense attorney's interview ethical, and can the prosecutor talk to the reporter? And so I think we have this happen quite a bit, depending on your defense bar and depending on your jurisdiction, where cases kind of do end up getting tried in the press a little bit because the defense attorney is making statements out of school, if you will, or giving those kinds of interviews to the press. And there is a rule that governs that, an ethical rule, and so we just need to be aware of that. I think most prosecutors, at least certainly in my office and most prosecutors I talk to, follow the golden rule of don't talk to the press while a case is ongoing. That's just the simplest, easiest way, but that's not what the rule requires, and so we do want to be aware of what the rule requires. And the rule says, a lawyer who is participating in the litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by public means and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So the rule has several parts, and it might be difficult to hold someone's feet to the fire, and we are smart to avoid trying cases in the press and not talking to the press while a case is ongoing. It's certainly okay after the case is over. But when you look at the rule and break it down, the extrajudicial statements outside of court, where you know or reasonably should know, one, that it's going to be disseminated by public means. Of course, if you're talking to a reporter, you know that. That's not a tough one. But the 2 and 3 will have a substantial likelihood, so that's a very high likelihood, of materially prejudicing the adjudicative matter. So those are kind of high hurdles to overcome if you're trying to hold someone's feet to the fire under the ethical rule, which doesn't mean that we should not act and respond to some of these things. Sometimes we may be required to respond if misinformation has been disseminated and we just need to correct the record. Or we may want to respond through the court and bring it to the court's attention so the court can take action in these cases where a defense attorney is constantly or routinely talking to the press and making it difficult later to select an impartial jury because they've been poisoned by over coverage in the press. So it doesn't mean that we don't respond, but the ethical rule may not be the way that we respond. But remember, there are things that we can talk about in these cases. A lawyer can state the claim, offense, or defense involved, and except when prohibited by law, the identity of the persons involved. So make sure that you're aware of your state laws and make sure that the defense is aware, because some states do have the rule and the law that you cannot reveal the name of the complainant, the victim in the case, and we want to hold their feet to the fire certainly on that. Information contained in a public record is always something that can be publicly disseminated. That an investigation of a matter is in progress, we can tell the press about that. The scheduling of any step in litigation we can talk about. A request for assistance in obtaining evidence or information, or a warning of danger. So you often will have to talk about those things. And you may have to correct something that is stated to the press that's in the record that has been misstated or is misinformation to protect your victim. I typically try and stay away from the press until the case is over. There are things that you can talk to the press about and make them aware of it, and there are things that we may need to do to correct what misinformation is in the press, and we also sometimes want to take steps to make sure that this doesn't happen again and again and again. The other thing about trial publicity is if you do have the opportunity to talk to the press, take that opportunity to get a good message out there about your community's response to sexual violence, that we encourage people to come forward, that we treat these cases seriously, and that we will thoroughly investigate and try and hold offenders accountable. We want to make sure that victims do come forward. We know it's wildly underreported, and anytime we have an opportunity to communicate that message to the public at large and make it easier for victims to come forward, we want to take that opportunity. So don't avoid that opportunity. That's not really commenting on your case specifically, but making a broader statement given that press opportunity. So think about those things when you have a press situation.
And it's worth pointing out that the rules that govern trial publicity are not different for prosecutors and defense attorneys. Defense attorneys do not have wider latitude to talk to the press about these cases. Although the consequences for violating the rules may be different, because prosecutors could be accused of a due process violation. They could do something that requires a change of venue if sensitive information gets out into the jury pool. So it's just something else to think about.
And just the final slide there talks about criminal cases specifically. The identity, residence, occupation, family status of the accused is something we can talk about. If the accused has not been apprehended, information necessary to apprehend him, the fact, time, and place of the arrest, the identity of the investigating and arresting officers or the agencies, and the length of the investigation. So those are just some additional specific areas that we can talk about per the model rules.
So back to our hypothetical case, let's now assume that the defense is filing a motion, a generic motion asking for the victim's counseling records, including all of the victim's psychological and psychiatric records. The defense is also asking for copies of the photos of all of the injuries from the sexual assault forensic examination, including photos of the vaginal injuries. So what do you think? Do you have to turn them over? And I know that there's a difference among jurisdictions, but in your jurisdiction, would you have to give over those psychological records? Assume that the counseling records are records from a counseling with at a rape crisis center. Do these have to be turned over? It's a little bit of a compound question. We're asking you about different areas. But Charlie, are we getting some feedback?
Yeah, so far we've got 67% saying no with 33% saying yes, and it's just fluctuating very slightly.
Okay. What do the rules say? Rule 311 of the ABA standards say that a prosecutor should not fail to make a reasonably diligent effort to comply with a legally proper discovery request. So, the question is this a proper discovery request? There's some very sensitive material there, and in some jurisdictions, like Pennsylvania where I practice, psychological records and counseling records from a rape crisis center are entitled to an absolute privilege, and they cannot be received by a defense attorney or by even the prosecutor. In other jurisdictions, there's in-camera review by a judge, and that may be a way to protect the victim and the victim's privacy. If you do have to give things over, if there are records, if there are images of the victim's injuries, including vaginal injuries, this is so sensitive. Consider maybe an order or complying with the request by inviting the defense attorney to come look at these things in the prosecutor's office, but not give them a copy of it. That's how a lot of jurisdictions handle child pornography, and that when a defense attorney needs to defend one of those cases, they may need to see the images. They may need to bring their expert in to see the images if the age of the victims is an issue, or if they need to determine whether the age of the victims is an issue. So there are ways of handling this. If a judge does order that it has to be turned over, we certainly don't want these images given to the defendant. Think about an offender who rapes a victim. Should he now have a trophy by way of a picture of the victim's genitalia? It's just something to think about. So keeping close tabs on them, not letting the defense having it, or if they do get it, giving it to them with restrictions and with court orders. Now, in this case, the defense has served the victim's psychiatrist and victim advocate with a subpoena for the victim's records. Is there anything you can... Oh, go ahead, John.
Well, anyway, I was just going to chime in with, remember about that the request has to be a proper request. They don't get to go on fishing expeditions. There has to be a good faith basis or reasonable reason to believe that the thing that they're trying to obtain contains evidence, relevant evidence in the case that may be exculpatory or may lead to exculpatory evidence. So again, you don't have to respond to you should respond to every discovery request, but you may respond with, we're not turning that over because you haven't demonstrated that there's any reason to believe there's going to be relevant exculpatory evidence in that source. So I just wanted to...
And John, sometimes the request is, I don't have this information. I didn't ask for it. I don't want it, especially with respect to the victim's mental health records. So I guess that's why we're changing the hypo now with this next wrinkle.
Yeah, and so, and this happens. Defense attorneys will serve. They'll bypass us. One, we may not be in possession of that. Two, they may not want us to know that they're trying to get that information. And they go directly to the psychiatrist and to the victim advocate with a subpoena for the victim's records. So what's the answer? Is there anything that we can do to prevent that testimony? And so there's a couple of interests that are involved here. There are two different types of privacy interests. One that involves personal decision-making or autonomy interest, and the other that's that confidentiality right, that right to confidentiality, and it's based on an expectation of privacy. And so we have matters that are confidential, which means that we're not required to automatically disclose those things even to law enforcement. There are some exceptions, but we may not be able to refuse to be a witness if a matter is simply confidential. And that contrasts with when a matter is privileged. A matter that is privileged, we can refuse to be a witness, we can refuse to disclose the material, refuse to produce an object or writings, and can prevent others from doing these things too. The privilege rests with the individual, the victim in our case, and they can prevent the psychiatrist or the victim advocate from turning that over. And Chris already mentioned, just remember, be aware of your state laws, because a lot of states have codified victim advocate privilege, victim advocate statements that they've made them privileged because it's such an important tool to get people the help that they need that we do not subject them to disclosure, even in cases of criminal cases where you would think that someone might have the ability to access them. That relationship is so important, and we recognize how important it is to get these victims the help that they need, that a lot of states have simply codified that privilege. But remember, if they're going around you, you still may want to object. You still may want to move to quash that subpoena. You may have the issue that the defense argues that you have no standing in this matter to assert the victim's privilege, rather, the psychiatrist's privilege or the victim advocate's privilege, or the privilege that covers them. And so you may want to hook your victim up with private counsel in your jurisdiction. And do you have that opportunity to do that? Because they may be the appropriate one to assert that privilege. Given HIPAA, et cetera, often medical providers do a good job already and make it tough, even when we try and access medical records that we're entitled to, because there's a criminal law exception to HIPAA where we can access some of those records as the prosecutor. But if they're not doing a good job, or if you're worried that it's going to happen, we should hook victims up with private counsel and make sure that that privilege is asserted.
And even though there may be a privilege, you never want the victim advocate or counselor to just ignore the subpoena and not show up. If there's a privilege, they need to assert that privilege, file a motion to quash, or come to court and assert that privilege, because it's important that you don't want them to get in trouble. They can't just say there's a privilege and I'm not going to court. There has to be a judicial determination that the privilege applies. Back to our hypothetical case. The victim calls you and tells you that she wants to drop the case. When you refuse, she tells you she lied about everything. After several counseling sessions, the sexual assault victim calls you and says she wants to go forward in the case and that she lied when she recanted. So she's basically staying with her initial disclosure to law enforcement. So the question we have is, how much of her statement to you must you disclose to the defense? This is actually a fairly common scenario. In many cases, a recantation is a victim's way of saying, I don't want to participate in this prosecution anymore, or I can't participate in this prosecution anymore. And the way we set up this fact pattern, it's almost as though she was unable to do it, but after more counseling, she is able to do it, and she does want to do it. But now you're in a position where you have heard from the victim over the telephone, at least someone who says that they're the victim, you have heard a recantation. So there's a rule, again, that applies to this. It's timely disclosure of all evidence that would tend to negate the guilt of the accused or mitigate the offense charged. A recantation to a prosecutor falls squarely within this rule. This rule really is a little bit of a codification of the Brady versus Maryland decision. It's Brady material. It's also required by the rules and the ABA standards. So this has to be turned over. Now the question is, how do you do it? It's a telephone call. At some point you're going to need to confirm that it was in fact the victim, truly the victim who made the call and not someone who is working with the accused. But you're going to have to somehow reduce that to writing. I know that a lot of prosecutors avoid talking to victims one-on-one to avoid this situation, but sometimes it's unavoidable. People may call your office after hours when you're answering the phone, or they may get through to you despite your best efforts. When that happens, it's best to just reduce the conversation to a very short memo, the date, the time, who called, what they said. The fact that the victim recanted is relevant. The fact that the victim said they didn't want to go forward with the case may or may not be relevant. You could decide whether you want to include that, but it's really the recantation that's the Brady material. There may be strategic reasons why you want to disclose the fact that the victim did not want to prosecute in order for you to later be able to argue and give the defense notice of that this was not a true recantation, but that it was a recantation as a way of the victim expressing her desire to not go forward with the prosecution. So, but the recantation does have to be disclosed. What after disclosure? Oh, John, this one's yours.
Yeah. So after disclosure of the victim's recantation and subsequent withdrawal of the recantation, the defense attorneys subpoena you and move to disqualify the prosecutor's office and request a special prosecutor be appointed. So can the prosecutor be called as a witness? And what argument would you make in requesting that the subpoena be quashed? So, I mean, theoretically, you could be called as a witness, and this happens sometimes, and typically it may just be a tactic to sort of disrupt the prosecution by trying to have you called as a witness and maybe have your office disqualified. So think about the rule that governs whether a lawyer should be a witness. And the rule is a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. And the key there is necessary, and this is per the model rules. Look at your individual state rules if you don't follow the model rules, because sometimes they're worded slightly differently and it could be important. But a necessary witness. So if you, as Chris talked about, how am I going to communicate this conversation, verify that it was the victim, and then communicate it to the defense? Well, turning that over to the defense in writing and then maybe stipulating that this is what the victim told you, or getting the victim to state it on the stand and sort of dealing with it in your case in chief to take the sting out of it is the other way to do it. If the victim for some reason isn't going to acknowledge that at some point, there are other ways to do it. It's always a good thing to have maybe another person, an advocate or your victim witness coordinator or somebody with you when you're talking to your victim if you can, so that they can be the witness and that you are not the necessary witness. In this case, there's a lot of things that you could do to avoid being a necessary witness, and so the ethical rules would not require that you be subpoenaed and not require you to testify. It would be important to let your judge know that and let the court know that there are many ways to cure this issue, and subpoenaing you as a witness isn't the only way. And back to you, Chris.
The morning of your trial, your paralegal comes into your office and tells you that the victim called and left a message over the weekend saying she did not want to go to trial and that she was leaving the state. When you get to the courthouse, the defense attorney approaches you and tells you that his client has decided to take the plea offer you previously made, so there's no need to go to trial. Now what do you do? I don't think we're going to have time. We're coming up on time. I don't think we're going to be able to do that. So let's take a look at the standards that apply here. A prosecutor cannot knowingly make false statements or representations as the fact or law in the course of plea discussions with defense counsel, but you should also not imply a greater power to influence the disposition of a case than is actually possessed. So to go back to our hypo, so the victim has fled. They've left the state. So you have a problem proving your case now, at least on this particular day. The question of whether you have to tell the defense about that is an interesting one. This is a great issue. We used to use this in our hiring interviews because it's very nuanced. It's not exculpatory evidence. It does not negate the guilt that the victim is not there. It negates your ability to prove the case. And the rules really do distinguish between your duty to give that information about whether it's something that affects the guilt or whether it affects your ability to prove the case. You may have an ability to track that victim down, to find them, to use compulsory process to bring them into court, something that we probably don't want to do in a sexual assault case because we don't want to use the criminal justice system to re-victimize the victim. But in terms of what you have to tell, you don't necessarily need to tell the defense that the victim is not there, but you also can't lie about it. So if the defense says, are you ready? Is your witness here? You can't lie about that. You have to tell the truth. You also can't imply a greater power to influence the disposition of the case. But if they don't ask you if the victim is there and they simply come in and they say they want to plead guilty, there could be a lot of different reasons for that. The defendant may want to just take responsibility, and so ethically, you're probably not required to tell that the victim is out of state, but you can't lie about it. Now, I know that there are lots of prosecutors who would want to, and they would feel that their conscience requires it, but the rules and the ethical standards really do not require that type of disclosure.
Chris, real quick before we wrap up, we got a great comment going back to the situation where the victim had a prior charge for indecent exposure where she lifted her top at some bar or some event, and the case was dismissed or not gone forward in. And the comment was, were those charges or that charge against this victim part of the same incident? And if so, couldn't it be perceived that the victim received something in exchange for her testimony? And that's actually a great comment. I think we were just thinking this happened sometime in the past. But make sure that you do reveal those things where it might be a minor charge when we talk about the alcohol or drugs and maybe they were charged by a police officer about something because of a revelation in a case that we could never go forward in anyway, but we got rid of that minor charge because we're focused on holding a serious offender accountable. We definitely want to turn that information over every time. You can't sort of eliminate potentially exculpatory evidence by not going forward in the case deliberately. And I just thought that was a good comment that we definitely want to.
That's a really good comment. And another point is anytime you have a victim or witness in the case who has open criminal charges at the time the crime is committed, at the time the crime is reported, or the time the case is being tried, that absolutely needs to be turned over to the defense for the exact same reason. The defense would then be entitled to make the argument that the witness is testifying a certain way for the prosecution with an expectation of some sort of leniency. So that is a great question, and I'm really glad that came in because it's sometimes difficult to do an interactive training by webinar, and that really pointed out some additional facts we need to give you. We're going to conclude with some quotes from Justice Jackson from 1940, where the justice really talked about how the fact that prosecutors have more control over life, liberty, and reputation than any other person in America. More than judges, more than juries, and really the justice talked about the position of a prosecutor to be vigorous in law enforcement, but also being just, and that even if the government technically loses its case, it is really won if justice has been done. This really speaks to trying difficult cases, fighting for victims, even cases that maybe are difficult to win. When you bring that case to court, when you try and hold an offender accountable that you know is guilty and try and give the victim access to justice, that really is the highest calling of an American prosecutor. The prosecutor should temper their zeal with human kindness, seek truth and not victims, serve the law and not factional purposes, and approaching the task with humility, just to keep in mind that the awesome power that prosecutors have. We want to thank you for the work that you do. Do you want to wrap it up, Charlie?
Yeah, thanks so much, Chris. I just wanted to let everyone know when you exit iLink, you'll be sent to our homepage, www.equitasresource.org, and you can register for future webinars and training events and review a lot of that information that Chris and John were mentioning at our library page. That link is also here as well. You'll also be sent a follow-up email, which includes our PowerPoint presentation as PDF, our presenters' biographies, full biographies, and a SurveyMonkey link. If you could please fill that out, we'd love your feedback to help us, in future presentations. And do please remember that Equitas is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, and training needs as they relate to prosecution of violence against women. So on behalf of Equitas, thank you again for participating in today's webinar. And remember that today's webinar was recorded if you had any issues or just would like to go back to it at a later time. Thank you all so much.
Moderator has disconnected. The call will now end.